Evening. Where you headed?
Home, just up the block. You mind if I take a look in the bag?
11 days before college?
Devin Marsh had exactly 11 days left before he was supposed to leave for state college on a full academic scholarship, and he had spent most of those 11 days doing precisely what he'd done every day that summer, closing out his shift at Fenwick's Grocery at 9, walking the 7 blocks home along Hastings Avenue, and replaying, in the quiet privacy of his own head, the exact wording of the acceptance letter that had arrived in June. We are pleased to offer you admission to the Morrow Scholars Program, covering full tuition, housing, and a book stipend for 4 years. He'd read it so many times he could recite it without looking, the way some kids memorized song lyrics. At 18, valedictorian of a graduating class of 211, the first person in his family to be offered anything close to a 4-year university, Devin had spent the entire summer working retail shifts, not because he needed the tuition covered, the scholarship handled that, but because his mother, Loretta Marsh, had raised him with the particular unshakable conviction that a young man headed somewhere important should arrive there having already learned what it meant to work for something with his own 2 hands. He crossed at the intersection of Hastings and Dell, earbuds playing low, backpack settled comfortably over one shoulder, and didn't notice the patrol car until its headlights swept wide behind him, slowing to match his pace along the quiet residential block. Officer Grant Selby had been working this beat for 6 years, and in that time had developed a private, unexamined instinct about which young men walking alone after dark on this particular stretch of road warranted a closer look. He'd never once had that instinct seriously tested by anyone with the standing to push back, and he had absolutely no reason, on this particular Tuesday evening, to expect that tonight would be any different. The cruiser pulled alongside Devin and slowed further. Devin, feeling the wash of headlights against his back, pulled one earbud out and glanced over his shoulder, more curious than alarmed. "Evening," Selby said through the open window, his tone carrying the particular performative friendliness that Devin, who had grown up in this neighborhood, who had been stopped twice before in his life for nothing more than existing on a sidewalk after dark, recognized immediately as something considerably less friendly underneath. "Evening, officer."
Where you headed?
"Home, just up the block." "Which house?" "The gray one with the blue door, 211. Selby's cruiser rolled to a full stop, and he stepped out, one hand resting near his belt, in a posture Devin had seen enough times in his life to recognize the shape of before a single further word was spoken. "You mind if I ask what's in the bag?" "My work uniform. I just got off shift at Fenwick's." Devin kept his voice even, his hands visible, the particular careful calm his mother had drilled into him since he was 12 years old. A set of instructions delivered not as fear-mongering, but as plain, necessary survival information. Keep your hands where they can see them. Answer clearly. Don't argue. Get home safe. We'll deal with whatever happened after. "You got ID on you?" "I do." Devin reached slowly for his back pocket, narrating the motion the way he'd been taught. "I'm reaching for my wallet now. It's in my back pocket." He handed over a school ID and a learner's permit. He wasn't yet 18 years and a day when he'd gotten his license, still working toward the full one, and stood, hands visible, while Selby studied both under the beam of a small flashlight. "You live at 211 Hastings?" "Yes, sir, with my mom." "That's a rental, isn't it?" "I believe so, yes." Something in Selby's private calculus, a young black man walking alone, a backpack, a rental address, all of it filtered through 6 years of unchallenged assumption, had apparently already settled on a conclusion before he'd asked a single, meaningfully relevant question. "Mind if I take a look in the bag?" "I'd rather you didn't, but I understand you're going to ask regardless," Devin said, echoing, almost verbatim, words his mother had once told him to use in exactly this situation: polite, precise, on the record, without ever refusing outright in a way that could be twisted into resistance. Can I ask what the actual reason for the stop is? Routine check. High incident area this time of night. It wasn't, in fact, a high incident area. Hastings Avenue had recorded exactly one reported incident in the preceding 18 months, a stolen bicycle. But Devon didn't have that statistic in front of him yet, and even if he had, he understood, with the particular weary clarity his mother had spent 6 years teaching him, that arguing statistics with an officer already committed to a search was not a fight likely to end well on a dark sidewalk at 9:40 at night. "Okay," he said quietly. Selby unzipped the backpack himself, rather than asking Devon to do it, a distinction that would matter enormously in the hours that followed. He rifled through a folded grocery store polo shirt, a paperback novel, a half-empty water bottle, and it was on his second pass through the bag's interior pocket, his body angled just enough to block Devon's direct line of sight, that his hand dipped briefly into his own jacket before emerging from the backpack holding a small plastic bag. "Well, what do we have here?" Devon felt the ground shift beneath him in a way no amount of preparation had ever fully readied him for. "That's not mine. That was not in my bag." "That's what they all say." "I'm serious, officer. I don't know what that is. I've never seen it. You put your hand in your own jacket before you—" "You want to add resisting to whatever we're about to charge you with? Keep talking like that. If you're already feeling your stomach drop right now, that's the point. Hit like and stay through this one, because what Devon's mother does over the next 39 minutes changes everything that comes after." Part 2. The phone call. Loretta Marsh was folding laundry on the living room couch when her phone rang at 9:52 p.m., and she knew, before she'd even looked at the screen, from the particular tightness already visible in the caller ID's timing against her son's usual walk home, that something had gone wrong. "Mom?" Devon's voice, when it came, was carefully, deliberately controlled, the exact tone she'd spent 6 years teaching him to use precisely so that whoever was standing near enough to hear the call wouldn't be handed anything they could later claim as evidence of hysteria or guilt. "I'm being arrested. Officer says he found something in my bag." "It wasn't there, Mom. I promise you it wasn't there." "I believe you," Loretta said, already moving toward the door, car keys in hand before the sentence had finished leaving her mouth. "Don't say anything else. Don't argue, don't explain, don't apologize. Just comply and wait for me." "Mom, the scholarship program. If this goes on my record before I said don't say anything else, baby. Not to him, not to anyone. I'm coming." She hung up and dialed a second number before she'd even reached her car. Not a lawyer, not yet, but her older sister, Renata, a paralegal who had spent 15 years working in a civil rights litigation firm downtown, and who had, on more than one occasion over the years, walked Loretta through exactly this kind of nightmare on behalf of other families in the neighborhood. "Renata, it's Devon. A stop on Hastings. They say they found something in his bag. He says it wasn't there." "I believe him too," Renata said, her voice instantly sharpening into the particular, focused calm of someone who had done this before and understood, with total clarity, exactly which minutes mattered most. "Where are they taking him?" "I don't know yet. Find out. Do not let them process him without you present if you can possibly help it. I'm calling Marcus right now." Marcus Reyes was a defense attorney Renata's firm worked with regularly on exactly this category of case. Young men, thin evidence, officers whose private, unexamined instincts had outrun the actual facts in front of them. And he answered on the second ring, already reaching for a legal pad before Renata had finished her first sentence. Part 3. Booking. They processed Devon at the 3rd Precinct, his personal effects logged and inventoried with the same bored efficiency applied to every intake that night, a process that would, in the days ahead, become one of the most consequential procedural details in the entire case. Because it was precisely that bored, unremarkable efficiency that ensured no one paused, even briefly, to question the account Officer Selby had already begun writing before Devon had been fully processed. Selby's incident report, drafted with the particular fluency of a man who had written dozens of similar accounts over 6 years, described a subject who had appeared nervous and evasive, who had attempted to conceal the interior pocket of his backpack, and who had, in Selby's characterization, made a furtive movement consistent with attempting to discard contraband, a characterization that bore no resemblance whatsoever to the calm, hands-visible compliance Devon had maintained through the entire encounter, but that would, absent any contradicting evidence, simply become the official record of what had happened on Hastings Avenue that night. Devon sat in a holding cell for the better part of 2 hours, his mind cycling relentlessly between the plastic bag Selby had produced from nowhere and the acceptance letters still sitting on the kitchen table at home, 11 days from a departure date that suddenly felt considerably less certain than it had that morning. Loretta arrived at the precinct desk within 20 minutes of the call, Renata close behind her, and spent the next hour and a half doing what generations of mothers in situations exactly like hers had learned, through hard and repeated necessity, was the only immediately available lever. Demanding, calmly and repeatedly, information that the desk staff seemed determined to provide as slowly as institutionally possible. "I need to know what he's being charged with." "Ma'am, processing takes time." "I understand processing takes time. I'm asking what the charge is." It was Marcus Reyes, arriving just before 11, who finally cut through the procedural fog with the particular, practiced authority of an attorney who had walked this exact hallway more times than he could easily count. "Possession with intent to distribute," he said, reading off the intake sheet a records clerk had finally, reluctantly, produced. "Based on the quantity listed here, that's a felony charge, and given his age, it's being processed as an adult offense." Loretta felt something cold and absolute settle into her chest. "He is 18 years old. He has never once been in trouble with the law in his life. He works at a grocery store and volunteers at his church on weekends and has a full academic scholarship waiting for him in 11 days. "I know," Reyes said quietly. "And none of that is going to matter tonight, because tonight is about processing and an arraignment date. What matters is what we do starting tomorrow morning." Part 4. What the camera didn't show. Or did. Marcus Reyes filed a formal discovery request the following morning, requesting, among other materials, the full body camera footage from Officer Selby's stop. A request that, under ordinary circumstances, might have taken weeks to fully process, but that Reyes pursued with a particular deliberate urgency once he learned, during his first meeting with Devon at the county holding facility, one crucial detail that Devon himself had nearly forgotten to mention in the fog of the previous night. "He unzipped the bag himself," Devon said, sitting across from Reyes in a small, windowless meeting room, his hands folded tightly on the table. "I offered to open it. He said no, he'd do it. And when he found the bag, his back was to me for a second before he pulled his hand out. I know how that sounds. I know it sounds like I'm just saying what I need to say, but I swear to you, that's what happened." "It doesn't sound like anything yet," Reyes said. "It sounds like exactly what the body camera is going to either confirm or contradict. And I intend to have that footage in my hands within the week, because Officer Selby's own department policy requires an active camera for any consensual search of personal property. And if that camera was recording, we're going to see precisely what you just described." The footage, when it finally arrived 9 days later, a delay the department attributed to routine processing that Reyes, and later a judge, would come to view with considerably more suspicion, told a story that diverged in almost every material respect from Selby's written incident report. It showed Devon standing calm, hands visible, answering every question clearly and without hesitation. It showed him offering, twice, to open the bag himself. It showed Selby declining both offers and unzipping the backpack personally. And in a detail that would become the single most consequential 11 seconds of the entire case, the camera, angled slightly downward from Selby's chest, capturing more of his own body than Devon's, caught the unmistakable motion of Selby's right hand dipping into the interior pocket of his own jacket a full 4 seconds before it reappeared inside the backpack's interior pocket, emerging a moment later holding the small plastic bag. Reyes watched the footage 11 times before he was fully certain of what he was seeing. Then he watched it a 12th time, this time with a forensic video analyst from his firm's regular consulting roster, who confirmed, frame by frame, exactly what the raw footage suggested. The motion was not ambiguous. It was not open to a reasonable alternative interpretation. Officer Selby had planted the evidence himself, on camera, apparently either unaware of or indifferent to the fact that his own body camera had captured the act in its entirety. Part 5. 11 Days. The 11 days between Devon's arrest and his scholarship program's mandatory arrival date became, for Loretta Marsh, a period she would later describe as the longest and most disorienting stretch of her adult life. A blur of court appearances, phone calls to the university's admissions office, and increasingly urgent conversations with Reyes about whether the charge would resolve quickly enough for Devon to still make his fall semester at all. The university, once informed of the pending felony charge, placed Devon's enrollment on a conditional hold pending resolution, a standard, procedurally unremarkable policy that nonetheless landed, in the middle of an already devastating week, like an additional and entirely separate blow. The scholarship itself remained technically intact, contingent on the charge's resolution, but the particular cruel arithmetic of the situation meant that every day the case remained unresolved was a day closer to Devon missing the fall semester entirely, deferring his enrollment by a full year, and re-entering an academic pipeline that, statistically, a significant number of deferred students never fully re-entered at all. "I need this resolved before the 15th, Loretta told Reyes in a phone call 4 days into the ordeal, her voice carrying a controlled, exhausted urgency. "Not because I don't understand the process takes time, because I understand exactly what happens to boys who lose momentum at 18, even boys who did nothing wrong. I've watched it happen to enough young men in this neighborhood to know precisely what's at stake here, beyond just this charge." "I know," Reyes said. "I'm filing an emergency motion for dismissal based on the body camera evidence tomorrow morning. Judge Okonkwo has a reputation for moving quickly when the evidence is this unambiguous. I can't promise the 15th. I can promise I'm doing everything within my power to get us as close to it as possible." The emergency hearing, held 6 days after Devon's arrest, unfolded with a swiftness that surprised even Reyes. The prosecutor assigned to the case, a young assistant district attorney named Priya Chandrasekaran, who had reviewed the footage independently the night before the hearing, arrived in the courtroom with an expression that told Reyes, before she'd said a single word, that the state's position had shifted considerably since the charge was originally filed. "Your Honor," Chandrasekaran said, once the hearing opened, "the state has reviewed the body camera footage submitted by defense counsel, and after consultation with my office's leadership, we are moving to dismiss the charge against Mr. Marsh with prejudice. The footage does not support probable cause for the original stop, and it raises serious, independent concerns regarding the conduct of the arresting officer that this office intends to refer separately for criminal review. Judge Adaora Okonkwo, reviewing the footage herself before ruling, did not mince words in granting the motion. "The court has reviewed Exhibit A in its entirety," she said, "and finds that it does not merely fail to support the charges filed against Mr. Marsh, it appears to affirmatively document the fabrication of evidence by the arresting officer. This charge is dismissed with prejudice, effective immediately, and Mr. Marsh's record in connection with this arrest is to be expunged in full." Devon, seated beside Reyes at the defense table, felt something in his chest finally loosen for the first time in 6 days. Not relief, exactly, not yet, but the first faint edge of it, still tangled up with 6 days of accumulated fear and exhaustion he hadn't yet had the space to fully process. If you've made it this far, you already know this isn't where the story ends. Hit subscribe, because what happens to Officer Selby over the next several months is the part that turns one family's nightmare into something considerably bigger. Part 6. What 6 years had buried. Reyes's referral to the district attorney's office for criminal review of Selby's conduct did not exist in isolation. Once flagged, it triggered an internal review process that pulled, almost immediately, a thread that had apparently been sitting untouched in the department's own files for years. 3 prior citizen complaints against Officer Grant Selby, filed over the preceding 6 years, each alleging some version of exactly what had happened to Devon. A stop built on thin, often fabricated pretext. A search that turned up evidence under circumstances the complainants insisted had been staged. And a report, in each case, characterizing the complainant as evasive or uncooperative in terms that bore little resemblance to their own accounts. All 3 complaints had been closed by the department's internal review process as unsubstantiated. None of the 3 had included body camera footage, either because the camera hadn't been activated, a violation of policy that had itself gone unaddressed in each case, or because, in one instance, the footage had been reported as corrupted and unrecoverable, an explanation the Internal Affairs Division had accepted at the time without further scrutiny. "I want to understand something," said Captain Marisol Vega, the department's newly appointed head of professional standards, during the internal hearing convened once Devon's case forced a full review of Selby's file. 3 prior complaints over 6 years, all describing nearly the same pattern. All closed without any camera footage being reviewed, in 2 cases because it apparently didn't exist, and in a third because it was conveniently unrecoverable. Can anyone explain to me how that happens 3 times before a 4th stop finally gets caught on tape? There was no answer that survived the specificity of the question, because the honest one, that Selby's private, unexamined instincts about which young men warranted suspicion, had simply never before collided with a family able to force the kind of legal scrutiny Loretta Marsh had brought to bear, was not one anyone in the department was in a position to offer without indicting the review process itself alongside Selby. Selby was placed on administrative leave within the week, terminated within the month once the department's disciplinary board reviewed the full file, and formally charged the following month with evidence tampering, filing a false police report, and deprivation of rights under color of law. Charges that, unlike the original case against Devon, carried the full weight of an unambiguous, unedited video record showing precisely what had happened on Hastings Avenue. Part 7. The Trial. Officer Grant Selby's trial, held 8 months after Devon's arrest, unfolded with the body camera footage as its unavoidable centerpiece. The same 11 seconds Reyes had watched a dozen times, now played for a jury on a courtroom screen, frame by frame, with a forensic analyst walking through exactly what the footage showed. A hand entering a jacket pocket, closing around a small object, emerging 4 seconds later inside a backpack that had, moments earlier, contained nothing but a folded work uniform, a paperback, and a water bottle. Selby's attorney attempted, over the course of the 2-week trial, the arguments such attorneys typically reach for in cases built on video evidence this unambiguous, that the footage's angle left room for alternative interpretation, that fatigue and stress from a demanding shift could explain an officer's momentary lapse in judgment, that 6 years of service without formal disciplinary action deserved weight against a single contested incident. The argument collapsed over the trial's second week under the combined weight of the video itself, Devon's own calm, precise testimony, delivered with a composure that several jurors would later describe in post-verdict interviews as more affecting than any display of anger could have been, and the testimony of the 3 prior complainants, each of whom took the stand to describe, independently and without ever having previously compared notes with one another, encounters that bore an unmistakable structural resemblance to what had happened to Devon. The most devastating testimony came from the 3rd complainant, a young man named Tobias Kern, who had been 17 at the time of his own encounter with Selby 3 years earlier, and who described, in a flat, controlled voice that carried its own particular weight in the courtroom, exactly how the department's internal review had handled his complaint. "They told me the camera footage was corrupted," Kern testified. "I asked how. Nobody could tell me. I asked to see the equipment maintenance log for that unit. Nobody produced one. I was 17. I didn't have a mother who could hire an attorney the way Devon's could. I dropped it because I didn't think anyone was ever going to actually look." Priya Chandrasekaran, who had moved from prosecuting Devon's now dismissed case to prosecuting Selby's, closed her argument to the jury with a line that would be quoted, in the weeks following the verdict, across multiple news outlets covering the case. "The defendant did not make a mistake on Hastings Avenue that night," she told the jury. "He made a choice. The same choice, apparently, that he had already made at least 3 times before, on the strength of a private conviction that certain young men in this city could be treated as guilty first and verified later, if verified at all. The only thing different about the 4th time is that, for once, his own camera happened to be recording the truth, instead of simply corroborating whatever version of it he chose to write down afterward." The jury convicted Selby on all 3 counts. The sentencing judge, not Judge Okonkwo, who had recused herself given her earlier ruling in Devon's dismissed case, but a colleague, Judge Elias Thornbury, imposed a sentence of 7 years with a permanent bar from law enforcement employment anywhere in the state, remarks he delivered with particular weight given directly to the 3-complaint pattern that had preceded Devon's arrest. "What troubles this court most," Judge Thornbury said before pronouncing sentence, "is not simply the 11 seconds of footage this jury reviewed, damning as they are. It is the 6 years and 3 prior complaints that sat, unexamined, in a file this department apparently never thought worth cross-referencing until a 4th young man happened to have a mother with the resources and the resolve to force the issue." This defendant's conduct did not begin on Hastings Avenue. It very likely would not have ended there either, had circumstance not finally handed this system a piece of evidence it could not quietly file away. Part 8. What 11 Days Cost and What They Didn't. Devon Marsh missed his fall semester at the Morrow Scholars Program. The university, once the charge was formally dismissed with prejudice and his record expunged, extended his admission and full scholarship by exactly 1 year, a gesture the admissions office characterized, in its formal letter, as recognition of extraordinary and unjust circumstances beyond the applicant's control. Language that Loretta, reading it at her kitchen table 11 months after the arrest, found herself feeling considerably less gratitude toward than the university perhaps expected, given how easily, absent Reyes's intervention and the body camera footage's unambiguous clarity, that same year could have become considerably more than one. He spent the deferred year working full-time at Fenwick's Grocery, promoted by that point to assistant shift manager, and volunteering, at his mother's quiet encouragement, with a local youth mentorship program specifically focused on helping young men in the neighborhood understand their rights during police encounters, a program that Loretta had, in fact, helped found in the months following Devon's arrest, drawing directly on everything she and Renata and Marcus Reyes had learned navigating the ordeal. "I don't want other families finding this out the hard way, the way we did," Loretta told a local reporter covering the broader story once Selby's sentencing became public. "I want them to already know, before it ever happens to their son, exactly what to say, exactly what to document, exactly who to call in the first 10 minutes. Devon had all of that, because I'd spent years absorbing it secondhand from other families in this neighborhood who went through their own versions of this, without the resources we eventually found. I'd like the next family to have it firsthand, before they need it." Devon gave a single public statement, standing beside his mother at a community forum the department held as part of its court-mandated policy reforms. Reforms that now required, per the district attorney's office's recommendation, mandatory quarterly audits of camera footage retention and functionality across every patrol unit, specifically to prevent the kind of unexplained, corrupted footage excuse that had allowed Tobias Kern's complaint, and likely others, to disappear without meaningful review. "I think about the 11 days between my arrest and the day I was supposed to leave for school," Devon said. 11 days that turned into a full year because a system that was supposed to protect due process instead very nearly cost me an education I'd worked my entire life for. I got that year back because my mother knew exactly who to call, and because, for once, a camera happened to catch the truth instead of losing it. I think about Tobias, and about however many other kids there might have been before him who didn't have either of those things. That's the part of this story I actually want people to sit with. Not what happened to me, because I got it back. What happens to the kids who don't? He enrolled at the Morrow Scholars Program the following fall, 1 year later than planned. The acceptance letter that had once sat untouched on the kitchen table for 11 anxious days, now framed, at his mother's insistence, in the front hallway of the house on Hastings Avenue. Not as a trophy, Loretta would explain to anyone who asked, but as a quiet, permanent reminder of exactly how close it had come to never happening at all, and exactly what it had taken, in the end, to make sure it did. The end.